Number 67, People v. Corr, and number 68, People v. McDonald.
Good afternoon, Your Honors. May it please the Court, Ava Page from Appellate Advocates on behalf of Bryan McDonald and Matthew Corr. May I please have 3 minutes for rebuttal?
Yes.
Thank you. The initial date of registration contemplated by Correction Law 168H1 is the first time Mr. McDonald and Mr. Corr registered for their underlying offenses, not their subsequent date of re-registration in New York. The plain language of the statute is clear and the court is bound by it. SORA was enacted as part of a comprehensive federal scheme.
Can I just clarify something? Let's say it happened, or something happened in reverse, or take this hypothetical. The person is residing in New York, their initial registration is actually in New York. They move to Massachusetts, register there, they move back to New York. Are they always registering in New York, or that pauses while they're in Massachusetts, actually change their residence, take it that they've moved for 5 years? When they come back, are they now doing another initial registration?
No,
How
Your
does that
Honor.
work?
No, Your Honor. Your initial registration date stays the same. So someone that registered in New York and moved to a different state is still required to register in New York. Their initial registration date does not change.
No, but what happens when they move back?
The period does not toll. It continues from the date they first registered in New York.
So they
Okay.
get credit for that time in the other
Yes,
state?
Your Honor.
Okay, so they would get credit going that way, but, okay. So
Yes.
if they were here for 5 years, moved to Massachusetts for 5 years, that adds up to 10. When they come back, they are at 10.
Yes,
They're
Your
not
Honor.
at 5.
Yes.
Okay, thank you.
Yes. And
I'm sorry, is there any requirement related to New York while they're in the other state?
I believe they are still required to, before someone leaves New York, they are required to inform New York authorities of their new address in the new state. There is a third department case that says you are still required to register once you leave New York. I'm not sure if that just consists of annually verifying that your address remains the same. But in any event, if the person moved back to New York, their initial registration date would be the same.
And what if they moved to France for 5 years?
I believe it would remain the same, Your Honor, because it's an immutable fact that doesn't change just because I moved to France or Maryland. It stays the same.
And it would be, I don't know if France has a sex offender registry, but let's assume they move to a country that doesn't have one. Do we know of any case like that, or what would happen?
No, Your Honor, even if someone were to register in New York and violate the terms of registration, it still doesn't start their registration period over.
But what would you credit? In the Chief Judge's example, if indeed they move to a place where there's no registration requirement, what are you crediting?
You would always credit the initial registration date.
But
It does
that's what
not-
I'm saying. You wouldn't credit the time in this other place where you're not registering? Is that what you're saying?
The New York statute would credit that, yes.
It would.
I don't
It
understand
would.
So if you were in a country that had absolutely no registration requirements at all, you just would have to tell New York, I'm leaving day after I register here, I'm coming back the day before my 20th anniversary, and now I'm done.
Well, Your Honor, I don't know when it comes to a different country. I know that there's a whole comprehensive federal scheme when it comes to that, as well as every state in the United States. But if I am convicted of a registrable offense in New York, I register in New York, and then I move to another state, I must report that to New York, and I must report that to the other state. And New York and the other state communicate and info share immediately as per federal law and the law of every single state. So if I were to fail to register in the new state, I would be subject to
Well,
felony.
that's about compliance, but the case is about crediting the time. So I thought your argument was if someone is registered in another jurisdiction and they're in compliance, okay, but they've registered, and so they're under the authority of that jurisdiction's SORA, I thought that was the argument, that's why you're crediting that. But again, in the Chief Judge's hypothetical, if the person moves to a place where they're not subject to any kind of registration requirement, they're not being tracked, they're not being, there's no authority over them in that way, again, my question to you is what are you crediting?
Sure. If I may confine the hypothetical to the 50 United States and territories.
Well, no, don't they all have a registration requirement? This is the
Yes.
point. If you move to a place where there is no registration requirement.
I don't believe that issue has been addressed, but under the current law, New York would credit the time since you first registered in New York.
But to go back to something you said on that, so I understand it. So you register in New York and now I move to Massachusetts. I believe you said that under federal law, then those authorities communicate with each other.
Yes, Your Honor.
Person's moving there, and then are you getting information back then from Massachusetts while the person is there?
Under federal law, yes, all of this information is shared to the federal government and between states.
So is that a little different than if I commit the crime in Massachusetts, I register in Massachusetts, I'm there in Massachusetts, why would they tell anything to New York until I get here, right?
If I commit the crime in Massachusetts, register, and then move to New York?
10 years later, I moved to New York.
Yes, that
Those
is-
first 10 years, which is what we're talking about hypothetically, right, the credit, in those 10 years, is there any obligation or process whereby Massachusetts is feeding any information to New York about what's going on there and what their supervision is or what the status is?
Well, all states report to the National Federal Registry, so yes, that is accessible by New York law enforcement. But importantly, New York, Delaware, and Massachusetts, the states that issue here, all require substantially the same registration for level 1 requirement, for level 1 registrants. So in New York, Delaware, Massachusetts, all registries maintain the same information. That's your name, your social security number, your physical description, your home address, your employment address, your school address, your offense details.
So is the rule that you're looking for, if you've been registered in a jurisdiction their registration requirements are equivalent to those in New York, you get credit, but if they're not, you don't?
Well, the rule that we're asking for is simply that all level 1s with no designation as adjudicated as such by a New York court get the years since their initial registration date towards the 20-year period. So this doesn't require New York.
Does the statute specifically say that?
The statute says initial registration date, Your Honor, and the meaning of that
But does it
is-
mention another jurisdiction where you initially registered?
It does not further define it, but it didn't have to because SORA has always been enacted to comply.
But when you look at other states, your adversary mentions Ohio and I think Maine, and I took a look at statutes from a number of other states, right? And what I'm wrestling with is many of them, I think almost all of them, either provide some very specific date, for example, your date of release from incarceration, or they set up some process, or they require you to register for life, and then you can go to a court to get relief. And when I look here, 168K, which says this is about registration for change of address from another state, it obviously doesn't have any process mechanism like that. And I take your plain language argument about initial registration date, but I would expect if the legislature meant that in the way that you're suggesting, that we would see some acknowledgement of how to do that. And I think as well, you know, when you look at the authority that the SORA board and the SORA courts are given by the statute, there's not some broad rulemaking authority or something like that. So what do we do about the absence of a process mechanism, which seems kind of singular? I don't know if it's absolutely singular, but certainly unusual.
Well, New York has already set up the perfect process mechanism for this, which is the SORA hearing. So at the SORA hearing, if an out-of-state individual moves to New York, everyone must have a SORA hearing that is registrable. At that hearing,
But isn't that really set up to deal with the risk level?
it is set up to find all the facts about the out-of-state person, including their criminal history, whether they're registrable, their conduct while incarcerated or supervised in the foreign state, any subsequent criminal history. So all this fact-finding of which initial registration.
But this
date is
wouldn't
one.
really be a fact-finding. This would be some sort of determination at the SORA hearing about whether or not to give credit. And it seems to me that what you would end up getting if you had the SORA court do it was individualized determinations that could be as different as the person who's doing the hearing, which is the benefit of having a statutory or even an administrative procedure in place for evaluating the standards for applying that credit. would you be advocating for a ad hoc determination as to each person who's seeking credit for time spent in another jurisdiction?
No, Your Honor. This argument only applies to people designated level 1, no designation by New York courts. So first of all, this is what the SORA court does in every single case.
But it doesn't look at a foreign jurisdiction, foreign being another state's jurisdiction, and say, is their supervision regime substantially equivalent to ours? Because that, to Judge Halligan's point, seems to be what some of these statutes that actually do this are getting at. So the legislature is making a determination, I think to Judge Cantaro's point, that this is substantially equivalent, and the judges are applying that framework to each case. Here, I'm not sure what they would do, because the issue isn't do you not have any violations in, let's just say, Massachusetts. The issue is, would Massachusetts catch the violations we would catch? You may have been violating all the time under our rules, but Massachusetts just isn't set up to have you under the same conditions. So how do you do that without a statute?
3 answers to that, Judge. First of all, Ohio and Maine don't provide for any hearing for the risk level classification. It's automatic. So New York already gives far more due process
No, but
rights.
the legislature's made a very explicit determination about how this question should be dealt with, right? In Ohio.
Yes, because they don't have a court decide someone's level, they had to provide a mechanism for applying for credit.
But to Judge Garcia's question, we could have, for example, one court or one department decide, if we were to conclude, I realize you might have a different view, but that the credit should be given for jurisdictions where there's equivalent supervision or requirements. You could have one court or department say, okay, Pennsylvania is equivalent, and another court say it's not. It just seems like an unwieldy process.
I understand that concern, Judge. The prosecution has not pointed out a single state that has materially different, let alone substandard requirements to New York. And that is because all states exist under this uniform federal comprehensive scheme.
So the natural conclusion of that statement would be you don't have to do some sort of qualitative assessment of the various reporting regimes or oversight regimes because it's level 1 and basically they're all the same.
Exactly, Your Honor. There is no need for New York to look at another state's statute, and that is not what Mr. Corr and Mr. McDonald are asking here. I see my time has expired.
What if there was a violation or noncompliance in the other state? That would be something that New York would be interested in knowing, not just necessarily what the level is, but is this person compliant? So before they come back, New York would want to know that. And what would be the mechanism to obtain that information?
Of course, Your Honor. May I answer? My time has
Please
expired.
go ahead.
Of course, New York would want to know that, Your Honor, and New York would know that. At the SORA hearing for out-of-state defendants, let's look at Mr. McDonald and Mr. Corr's SORA hearing. The New York SORA court, the New York prosecution, knew everything about their prior criminal history, which was none, the facts of their offense, non-contact, non-violent offense, the facts of their sentences, probation, the facts of any subsequent criminal behavior, which there was none. So the New York SORA court has all this information. If someone has committed another sexual offense or any sort of criminal misconduct, that will result in an upward departure, which will require lifetime registration. So this argument would not apply to them. If I just may briefly conclude, the initial date of registration is an immutable fact, like my birthday, my criminal record, my date of professional licensing or vaccination that does not change when I move states. And New York routinely accounts for out-of-state facts such as these in all of our proceedings. This court recognized this in Jones from 2015. This is exactly what the SORA court does and what happened here when everyone agreed that Mr. McDonald and Mr. Corr were unanimously level 1s, posed the lowest risk possible, and their initial registration date was uncontested. So this in no way requires New York courts to look at other states' registration laws, only the objective fact of initial date of registration. If someone has not been compliant with registration, that will result in a felony conviction.
Not with registration, not compliant for their level 1 requirements. How would New York know?
That would be a violation of registration, Your Honor. If there's any violation of reporting your registration requirements, which if any of the information I stated, like your address, your internet identifiers, if any of that changes, you have to report that within 3 days in Delaware and 10 days in New York and Massachusetts. So it's a strict liability crime.
And who are you reporting it to?
The local law enforcement authority. So all of the states know if someone has not registered, and that's how failure to register prosecutions are made. And then the receiving state, per New York law and per federal law, has all of that information. So New York courts are making extremely nuanced fact-finding, not only the initial date of registration, but all subsequent criminal history in the sending state.
Thank you.
Thank you.
Good afternoon, Your Honors. The entire New York SORA statute makes clear that the initial date of registration under 168H1 was not intended to be registration in any other jurisdiction under any other SORA statute.
Counsel, could you just address this, one of the latter parts of this argument with your opponent, that, and I just don't know this, level 1 registration requirements in all other states are, would you agree, are substantially equivalent to New York's?
No, I would not agree with that, because the federal system permits some variations in the level of notification and the amount of time that they require for verification. And also, there's the unknowable factor, even if the statute is on all fours with New York, of how the enforcement is handled in those states. And Your Honors have to decide this issue, not just for Massachusetts and Delaware, but for all states and territories that have SORA statutes.
You're basically saying that the system that the federal government has spent a lot of time encouraging the states to set up is something that we can't trust.
No, I'm not saying that, Your Honor. I'm saying that they set up the system.
Right.
They allowed for some variation. They allowed for, if,
What would be the variation at level 1? Give me any jurisdiction that varies when it comes to
well,
level 1, like this.
I didn't do a 50-state survey of all the variations, but the statute could be exactly the same as New York's. However, the enforcement of that statute could be vastly different.
That's what I'm
and the
saying.
legislature-
But that's what I'm saying. The uniformity of the system tells us otherwise. That's what Congress set up. Again, a lot of time was
Well-
spent on encouraging the states to set up a particular type of system. Yes, you're correct, of course, that each state does have some flexibility. I'm not going to
There are
dispute that with
variations.
you.
They can be less strict, and we don't, statutes are amended all the time,
Mm-hmm.
and the legislature in New York could have taken that into consideration, could also, a state could decide tomorrow that even though they're going to forego some federal funding, that they don't want the statute. They could also
Well, then
decide,
there's nothing to credit, right?
that's true.
If you're not
Okay.
under a registration regime,
Right.
there's nothing to
That's
credit.
absolutely correct. They could also decide, we don't have enough funding right now to enforce this well, or they could lack the motivation to do it. So the legislature.
That could be true within New York State too, right? And the enforcement is done on a local level, no?
Pardon?
That could be true within New York State as well. Some counties or municipalities might have the same resource constraints or not.
But the legislature has to determine this based on its view of New York's enforcement. They have some
Well,
knowledge that New York.
And maybe that view is there's a lot of variability, but it's roughly within an area we're willing to tolerate, and so that variability across states maybe doesn't matter either.
Well, I think that New York has set forth this, the entire statute shows that it intended not to take into consideration the enactments of
How
other states.
how
And-
so? Where in the
Okay,
statute do you see
so
that?
there are a number of, if you read SORA as a unified whole,
Yeah.
if you take a look at 168K,
Mm-hmm.
it sets forth in excruciating detail all of the requirements of DCJS, the Division of Criminal Justice Services, the board, the court, all the things they have to do to reach a risk level determination. They say nothing about
But what about what
finding
I,
out.
sorry, go ahead.
They say nothing about finding out when this offender registered in another state, about whether they complied fully, whether the state statute is on all fours with ours. If there had been an intention to include another state's SORA, that would have been within that section.
What I take your adversary's argument to be, I'm sure she'll correct me if I'm misstating it when she gets back up, but which is that initial registration date is as readily ascertainable as my birth date or yours.
Yes.
And so that's all we need to know. That's clear guidance. And if there are not, in fact, significant variations one state to another in terms of supervision requirements, given the umbrella of the federal law, that you wouldn't expect to see anything further in 168K. You don't need to.
Well, you would certainly need to see some mechanism for finding out whether the defendant has complied with such, when the registration date is.
So what exactly would you need to know? The registration date
Well-
is presumably fairly readily ascertainable. Would you need to know whether there have been
Whether there
periods
was
of noncompliance?
compliance, and what the statute says in the other state. You would need to know that because there are variations. They may not
Well,
be.
why isn't that
I thought-
information that would be resolved at a SORA hearing? Wouldn't it be the burden, excuse me,
Sorry.
wouldn't it be the burden, thank you, of the individual who's subject to registration, who's moving here and will be subject to New York registration, to come forward with evidence of when they initially registered, and again, there is communication within this system, so that you would have a record of whatever their violations are that have been recorded. And you could present that to make whatever argument you wish to make. But it doesn't change the initial registration.
Well, the initial registration doesn't change the initial registration in New York. If the legislature had intended any other jurisdiction, they would have put in there what is required. And I'll give you an example of why.
But given that
such-
people travel, one would think, actually, that they would have said the initial registration in New York, as opposed to the initial registration date, which is all-encompassing.
Well, it's a New York statute. Most statutes, if they're defining something or giving an example of something, they
Except
don't
that SORA
say
is,
in this
except that SORA is part of
state.
an integrated system under the federal statutes. You're trying to comply with federal statutes as well as, you're right, have your own flexibility.
Okay.
Can I ask you, you
Could I-
indicated with respect to 168K,
Yes.
and that it is detailed with respect to the requirements of registration.
Yes.
But it doesn't mention anything about credit.
Correct.
So is it your argument that because it speaks to very specific things and doesn't mention that that is why credit is not something that was contemplated?
That's one of my arguments, yes, that this K is specifically directed to sex offenders who are coming in from another state, and this is what the board has to do, this is what DCJS has to do, this is what the court has to do. And the reason that the legislature presumably would have provided for this is exemplified by what happened in the Corr hearing. Corr hearing, there's no prior independent determination of the things that the court would have needed to know if it was going to provide credit. The date of registration, did he comply? Was the statute commensurate with ours? Was it stricter? Was it not as strict? And they couldn't know the enforcement, obviously. So what happened in the Corr hearing? First of all, there's none of that. The defendant doesn't provide any documentation of the date or the compliance and relies on defense counsel's say-so.
Let me ask you this hypothetical. Let's say you have an individual, we'll just keep with Massachusetts for the moment, lives in Massachusetts, 19 years and 6 months, and decides they want to come to New York, right? They move to New York one day before the 20 years, right? During that time, those few months I said, they decide they want to move to New York, they do whatever they need to do to prepare for that, and one day beforehand they move here. Under your rule, of course, Now they have to register for another
Yes.
20 years, correct? Okay.
Correct.
Well, now you have another person, let's say that's even the same sex crime. I'm not even going to change anything like that. Both are level 1, also moving from Massachusetts, moves here the day after 20 years. You say they don't have to register.
Correct.
How can that be what the legislature intended? How does that serve the interests, both of New York as its own sovereign, the people of New York, as well as within a state that's part of this larger federal system?
The legislature may well have weighed the possibility of such a hard case, and it is a hard case, I acknowledge that, by recognizing that some of the other states,
Well, there's not anything in the legislative history, I don't think, but correct me if I'm wrong, that indicates a consideration of this question specifically.
no, but the statute itself shows that they have decided not to give credit.
Through the silence.
Well, they haven't given credit.
Or perhaps that they did not directly consider the question.
Well, they might have, but what the statute says is what the statute says. So K didn't provide for a procedure for determining it. The legislature could have said, under this section, date of registration in any jurisdiction. It could have provided for credit. And there's another section of SORA which seems to indicate that if they had intended it, this meaning that the defense is putting forward, they would have written this section differently.
Counsel, can I
Correction
ask
law-
you a somewhat related legislative question? One of the first things that I thought when this appeal showed up was, why are we getting this question now? SORA's been around for such a long time. I would think that other level ones have come to New York from different jurisdictions
Many.
and wanted credit.
Many.
And part of the answer that I found to that question is courts have been doing this. Courts have been giving credit for this. And I'm just curious, what do you say to those courts? Have they acted completely in the absence of legislative authority to do what
Yes.
they did?
Yes, and not all courts have done that. If you don't give credit, if somebody had come and said, please, here in court, give me credit, and the judge just says no, what happens is the level 1, 2, or 3 is circled, and it goes off, and the person registers. Unless there was an appeal, there would be no appellate.
And one would think they'd be
Decision.
incentivized to do so because it's a long time to be on the registry. You have
So-
nothing to lose in that way, right? If you're not going to get the
Exactly.
credit, you're not
And
going to get the
so-
credit. Can we get back, though, to my question, because I don't think you had an opportunity to answer it. I asked you, what was furthered in my hypothetical? What policy was furthered if we applied the rule, as you say, to my hypothetical? I think you were going to try and answer that for me. You said they were hard cases, but
Well,
I think you were going to try and
Yes,
answer that.
the policy that would be furthered is if the legislature decided that certain jurisdictions were not enforcing
Okay,
the policy, that what the result of that would be,
Yes.
I don't mean not enforcing the registration, but say their law enforcement agencies didn't use the registration information to try and prevent crime or
no,
solve
but in my
crime.
hypothetical, they're coming
I
from
am
the exact
answering your
same
question.
jurisdiction.
Pardon?
In my hypothetical, they're coming from the same jurisdiction, same law enforcement scenario.
The same as what? I'm sorry.
My hypothetical was they're both coming from Massachusetts. One
Oh,
comes a
okay.
day before 20 years, one comes the day after.
Right.
And as I understood your
Right,
interpretation of the
but-
statute, the one who came here one day before 20 years now has to
Right.
register for 20 years. The one who came here one day after 20 years does not.
The reason I'm answering in the
Yes.
broad is that what the legislature has done,
Yes.
the rule that the legislature has imposed, has to be a universal rule. It can't be picking, Massachusetts or Delaware, okay, you get credit if you come from Massachusetts, and you don't get credit if you come
Yes,
from
but whether or
this
not the legislation is interpreted as you say is now for the court to determine. So my question is, again, since SORA is about furthering a particular policy about public safety and information so that
Yes.
law enforcement can track, how is that furthered given my hypothetical and given the way your interpretation of the statute would apply.
It is furthered in the broad by the legislature's determination that if the law enforcement agencies are not using this information, an offender could well have reoffended, and the SORA court would not have known, because the other jurisdiction is not using this information, is not cross-referencing, is not enforcing. And that would be the policy reason that the legislature decided that it was only going to use New York's registration for 20 years, because that advances the policy reasons. If I could, just like to add, if Your Honors would look at 268F2, which also shows that the legislature didn't intend initial date of registration to be in another state. That provision says, for a sex offender required to register under this article, meaning the whole SORA, on each anniversary of the sex offender's initial registration date during the period he's required to register, the following should apply, and then they mail verification forms, et cetera. The import of that is that DCJS wants the information on the sex offender once a year on the anniversary of the registration. So assuming for
Sorry,
arguments...
of the initial registration.
Yes,
And
initial
that doesn't help us
registration.
know which of those two it is.
So say, hypothetically, our two defendants registered in New York today, okay? Assuming that the initial date of registration is their date of registration in Massachusetts and in Delaware, they would have to mail their registration form in today, and then in the case of Mr. Corr, who registered in Massachusetts in January, he would then have to send a second form in January. In the case, that's 8 months later. Mr. McDonald would have to send his in August, in 3 months. So would the legislature have intended DCJS to get 2 forms in 1 year? I mean, the language of the statute, the implication of all these sections is this is an initial registration in New York. If they'd meant in another jurisdiction, they surely would have said so. And if they meant to credit, they also would have provided for that.
Thank you.
Thank you.
SORA has always...
Counsel, can I ask you, sorry to interrupt you,
That's
but
okay.
what's your response to the level of detail in 168K? And the granularity with which the legislature clearly considered how to proceed when you come in from out of state?
Yes, Your Honor. To that, I would respond, SORA has always been a statute of reciprocity that recognizes people will move from out of state to New York that must register. SORA was enacted to comply with federal law. It's been amended to comply with federal
Okay.
law.
But you agree there's nothing in there that suggests that the legislature took account of specifically the question of crediting time, although it took account of a lot of other things?
I would say that in Correction Law 168H1, it's clear that the initial registration date for out-of-state people, for anyone adjudicated level 1, no designation, is 20 years. So it did not need to be specifically spelled out.
And in the federal system, I think you were referencing some of the, if I understood you correctly, information that's available, right?
Yes.
If someone comes to New York and says, I want credit for 5 years of registration in another state, any state, how is it that the SORA board or the court, the SORA court, can ascertain whether or not that individual was in compliance with registration during those X years?
Yes, Your Honor. So in every SORA hearing for an out-of-state person that must register, DCGS, the Division of Criminal
Yeah,
Justice Services, gets all of that information from the sending state and gives it to the Board of Examiners. This is in the statute.
Okay. In the
New York.
corrections law or in the federal, in the Wetterling Act?
Both,
Okay.
but in corrections law.
Counsel, it seems to me, we're talking about SORA and the federal law. Maybe this is the wrong way to look at it. I always looked at this scheme as kind of a federalism issue, right? The federal government can set a floor, And New York can build off of that, depending on what protections the New York legislature feels residents in New York deserve. So they can build up. Now, if they do that, and they decide 20 years under these conditions is enough to satisfy us that the person no longer has to register, can't they also say those 20, we could do it a number of different ways. We could insist that you do that in New York, or, as Maine or Ohio has done, we can say, you have to show us under this framework that other jurisdiction is substantially equivalent to what our state has said are the requirements for your 20-year registration. So 19 and a half is a tough hypothetical, but really what the state is saying is we want 20 years under our conditions, and the way we're ensuring that is if you choose to move in here, you're doing 20 years under our regime.
Your Honor, I think what's telling is that, as Judge Canatero pointed out, numerous judges across our state have interpreted initial date of registration.
We've had cases where numerous judges are doing various things, even in SORA, and we've said no, because sometimes the issues are open. What we have to decide now is what did the legislature think they wanted to do in terms of protecting New Yorkers in this context? So what it seems a very compelling argument is they could have done this in a number of different ways, but they chose to do it by insisting that you have to do 20 years under these conditions of supervision for us to be comfortable with you being released from a registration requirement. That may have harsh effects in certain circumstances. The other way for the legislature to do it would be the way Ohio and Maine has done it.
No, Your Honor, because New York legislature has specifically held this issue as resolved at the SORA hearing. And it's notable the prosecution does not cite a single case besides these two decided by the same hearing court where New York courts interpreted 168H1 to deny credit to this population deemed to pose the lowest risk of ever reoffending by a New York court. The court cannot do statutory interpretation supported by fear-mongering that does not exist with a shred of evidence. The prosecution can't cite a single case that has different registration requirements than New York, which makes sense because SORA was enacted and amended under this comprehensive federal law.
Why would those other states bother to have that mechanism then?
Because they don't have any due process hearing, Your Honor, so there's no fact-finding going on.
But why would they need to have these criteria to look at if they're all the same system? Like if you're saying every level one system is the same, why would you need anything?
Well,
As long as you've registered level one in another state, you should just automatically get credit under your view.
Exactly, and many states do that. It's a very simple process to determine someone's initial date of registration. And to Judge Singus's earlier question, any noncompliance is known by the SORA court. My office does these hearings every day. If someone out of state is coming here that has been rearrested, convicted of any offense, especially a sex crime, any failure to register, the court knows.
But the issue, I think, is whether New York would be confident that those types of violations are caught in the 19 and a half years a person is under another supervisory regime. Not whether they were caught. I think clearly you're right, they would know that. The confidence.
Or if the reporting was different, if they said, you know what, in Arizona, you have to just check in every 3 years. So we wouldn't know what was going on there in year 2, 1 and 2, because they don't have to check in, or year 4 and 5. And New York is saying, you know what, we want to know.
And I think it's telling, again, that the prosecution cannot point out a single state that's different. If there was one that was subpar to New York's, surely they would have brought it up in their brief. The states at issue here are nearly identical. All level ones have to verify annually. In New York, in Delaware, and Massachusetts. All level ones need to report.
But what about the rest of the country?
Again, if there was any differentiation, I'm sure the prosecution would have brought it to the court's attention, but there's not because.
So if we could find a state where they do something roughly analogous to what your adversary says New York is doing or should be doing, which is you start fresh when you come to New York. It's a new 20 when you get here. What does that do to your argument? Especially the federalism argument that we have some sort of nationalized system where everyone's giving credit for everything else that happened in another jurisdiction.
Well, I would say if the court found another state didn't give credit, it does not take away from our argument here.
Why is that?
Because the New York legislature has been clear for this population deemed to pose the lowest risk of ever reoffending, like Mr. McDonald, who was a teenager in college when he filmed a fellow student in the shower, which would not even be registrable in New York. So for this very sympathetic, low-risk population, we want to give credit from the initial registration date because we recognize...
Why wouldn't that, I'm not really clear why you're going down that road, but maybe I'm wrong on this. Why isn't this just, as I understood the interpretation that you have argued for, why isn't this just a question of the burden of proof? I mean, look, your clients want the credit, they got to make their case. They got to show the initial date, they got to show that it certainly seems possible that they would have to show that indeed they were under a regime that's equivalent to New York. Why isn't that just a burden of proof?
Well, Judge, looking at the hearings here, the initial date of registration wasn't contested by the prosecution or the judge.
But I'm saying in terms of interpreting the statute.
That the registrant be required to provide documentation.
And
of
you've got
their-
other burdens, I mean, right? They're arguing for whatever level of classification, and as I understood it, counsel is arguing for credit. Counsel's got to make the case for the credit.
Yes, if, I would say that the statute clearly intends for the initial date to be honored. If this court were to fashion a rule going forward about who needs to provide that evidence, that does always come from the sending state, but if the court wants to put the burden on an individual to show paperwork saying, look, here's the first date I registered on official documentation from the other state.
I'm talking about this other question that my colleagues are asking about, right? To say, look, it's equivalent. You're saying you can just see what the law is with respect to registration, what the requirements are in that other state. Of course, your client would have been subject to it, so they would know what it is, and that allows the people to respond that there shouldn't be credit because it's not equivalent. I think, doesn't that address the issues? I mean, I may be misunderstanding your argument. This is why I'm asking this.
I think asking the New York SORA court to conduct a in-depth analysis of other states' registry laws is not what's contemplated by the statute. If that's the remedy that the court wants in our favor and the best one we're going to get, that's fine. But I think the SORA statute is clear that the court just looks at initial registration date. They have all that information from the sending state. If it's not clear or if it's contested, they don't get credit. But notably in both of these cases, everyone agreed that the initial date of registration was for Mr. McDonald, August 20th, 2015, for Mr. Corr, January 29th, 2016. They're not asking that they shouldn't be required to register in New York. They're not asking New York to apply another state's law or risk level determination. And they're certainly not trying to avoid criminal liability for failure to register. They just want the court to apply the plain language of the statute to give them the appropriate years towards their 20-year period in New York since their initial date of registration.
I'm sorry, last question, if the Chief Judge will allow me, I do promise it's the last one, just to follow up on this. So then, under your interpretation of the statute, it's automatic once you show the initial date of the registration in the other jurisdiction, and the people would have no opportunity to challenge that at the SORA hearing?
That is the rule that the statute sets forth. And because the initial date of registration is just part of the facts of the case. If someone has not registered, if someone has been convicted of any crime, that will be dealt with through an upward departure, which the prosecution has the opportunity to make, and the court will certainly enforce, and that person will be a level 2 or 3 requiring lifetime registration, and this argument won't apply. So just like every SORA hearing, the court does this comprehensive analysis and can easily determine the initial date of registration. If there's any question, credit should not be given. If it's disputed, if it's unclear, credit should not be given. But in both of these cases, it was uncontested, and credit should be awarded.
Thank you.
Thank you.